Setting the context of crime and punishment in the UK is essential to understanding its evolution and current state, encompassing historical developments, legal frameworks, and societal perceptions. The concept refers to the comprehensive backdrop against which crime and punishment operate, including the historical trends, legal changes, societal attitudes, and pivotal events that have shaped the UK's approach to justice. Its significance lies in providing a foundation upon which the intricate details of past and present practices can be understood, revealing how evolving values and knowledge have influenced the justice system. One illustrative example is the transition from brutal public punishments in the 18th century to more rehabilitative approaches in modern times. This shift underscores the changing attitudes towards human rights and the efficacy of punishment in preventing crime. Another example is the influence of key legislation like the Police and Criminal Evidence Act 1984, which reformed police powers and protected the rights of individuals during criminal investigations, highlighting the balance between law enforcement and civil liberties. Support for understanding the historical context comes from various quarters. Many historians and criminologists argue that analyzing past practices and policies helps identify patterns that inform current strategies, allowing for more informed decision-making and better outcomes in reducing crime and recidivism. Furthermore, acknowledging historical injustices, such as wrongful convictions or discriminatory practices, is crucial in building a more equitable justice system. However, challenges and controversies are inherent in this analysis. Some contend that an overemphasis on historical context could detract from addressing immediate issues within the system, such as overcrowding in prisons or the effectiveness of rehabilitation programs. Others argue that historical interpretations can be subjective, leading to differing opinions on the lessons they impart for today's policies. This contextual understanding directly influences other aspects of the topic, such as contemporary practices and personnel involved in the justice system. For instance, recognizing past failures or successes in crime prevention can guide current law enforcement training and judicial processes. Furthermore, understanding the context helps evaluate the outcomes of crime and punishment strategies, providing insights into their societal impact and effectiveness. By setting the stage with a well-rounded view of its history and framework, one gains critical insights into the complexities of crime and punishment in the UK, enabling a deeper appreciation for how its past continues to shape its present and future trajectory. The historical overview of crime and punishment in the UK encompasses the evolution of legal systems, societal norms, and the underlying philosophies that have shaped how crime is addressed and punished. This concept is pivotal in understanding the broader context of crime and punishment, as it reveals the origins and transformations of policies and practices that continue to influence modern systems. Through the centuries, the UK's approach to crime and punishment has seen drastic changes, shifting from brutal physical punishments to a more rehabilitative and restorative justice focus. One significant period was the introduction of the Bloody Code in the 17th and 18th centuries, where over 200 crimes were punishable by death. This era highlighted the harshness of early criminal justice, but also set the stage for later reforms. For instance, the early 19th century saw the abolition of many capital offences under the influence of reformers like Sir Robert Peel, who also founded the Metropolitan Police Service in 1829, bringing about a paradigm shift towards organised law enforcement. Another example is the establishment of the penitentiary system, which marked a move from public executions to imprisonment, reflecting changing attitudes towards crime and punishment, emphasizing deterrence and rehabilitation. The significance of this historical perspective lies in its ability to provide a foundation for understanding current practices and debating future reforms. By recognizing the patterns and motivations behind past actions, we can better appreciate the complexities and challenges of contemporary criminal justice policies. Moreover, historical awareness elucidates the social, political, and economic factors that have influenced changes in punishment methods, from corporal punishment to modern incarceration and community service. Opinions supporting the importance of historical context argue that it informs policymaking by highlighting past successes and failures, thereby preventing the recurrence of ineffective or harmful practices. However, challenges arise in the form of controversies over past injustices, such as the disproportionate targeting of specific social classes and minorities, which continue to resonate today. Additionally, some alternative viewpoints question whether reformative approaches truly address the root causes of crime, or if they simply recycle offenders within the system. Overall, the historical overview connects deeply to other aspects of crime and punishment, such as the evolution of policing strategies and the development of legal rights, forming an intricate web of influence that shapes current and future policies. Understanding this history is crucial for anyone looking to engage meaningfully with the ongoing debates about the most effective ways to handle crime and administer justice in a fair and just society. The evolution of legal frameworks and practices in the UK is a cornerstone of its crime and punishment narrative, reflecting how society's approach to justice has transformed over centuries. This concept involves the development and refinement of laws, legal institutions, and judicial procedures that define what constitutes a crime and how justice is administered. Understanding this evolution is crucial for grasping how current practices emerged and how they address both historical and contemporary issues in UK society. The significance of this point lies in its direct impact on how crime is perceived, controlled, and punished in the UK. As new social challenges arise, legal frameworks must adapt to ensure justice remains fair, efficient, and relevant. This evolution also mirrors broader social, political, and economic changes, influencing how laws are interpreted and enforced. One significant example of this evolution is the development of the Magna Carta in 1215, a landmark document that laid the foundation for modern legal systems by establishing principles like the rule of law and due process. Another example is the gradual abolition of the death penalty, culminating in the complete cessation of capital punishment in 1965. This shift reflects changing societal values and the growing emphasis on human rights, rehabilitation, and humane treatment of offenders. Opinions supporting the evolution of legal frameworks often highlight the necessity of adapting laws to ensure they reflect contemporary values and challenges. Proponents argue that such adaptability is vital for maintaining public trust in the justice system and ensuring that it effectively deters crime while protecting individual rights. However, this evolution is not without challenges and controversies. Critics may argue that frequent changes to legal systems can lead to inconsistencies, making it difficult for citizens to understand their rights and responsibilities. Additionally, there is often debate over whether legal changes adequately balance the needs of victims, offenders, and the community. This evolution also connects to other aspects of crime and punishment in the UK, by influencing law enforcement practices, shaping the roles and responsibilities of legal personnel, and determining the outcomes of judicial decisions. It underscores the dynamic nature of the justice system and its ongoing quest to balance order, justice, and fairness in the face of evolving societal norms. Understanding these connections provides valuable insights into how past legal transformations continue to shape current and future practices in crime and punishment in the UK. Influential figures in UK criminal justice have played crucial roles in shaping policies, reforms, and societal attitudes towards crime and punishment over the years. These individuals, whether they are policymakers, legal professionals, reformers, or activists, have contributed significantly to the evolution of the UK's justice system, impacting everything from legislation to public perception. Understanding these figures is vital in analysing the history and development of crime and punishment in the UK. Their contributions often highlight the changing attitudes towards justice, reflecting broader social, political, and economic shifts. Examining their influence helps us understand the balance between punitive measures and rehabilitative efforts, and sheds light on the ongoing debates about fairness, effectiveness, and human rights within the system. One notable figure is Sir Robert Peel, who established the Metropolitan Police Service in 1829. Peel's principles of policing, emphasizing prevention over apprehension and the importance of public cooperation, laid the foundation for modern policing not only in the UK but worldwide. His work underscores a shift towards more organized and professional law enforcement, highlighting the need for balance between authority and public trust. Another key figure is Elizabeth Fry, an early 19th century prison reformer whose efforts to improve conditions for female prisoners led to significant changes in the UK's penal system. Her advocacy for treating prisoners with dignity and humanity introduced the notion that the justice system should rehabilitate rather than solely punish, a principle still relevant in contemporary discussions on criminal justice reform. Supporting these ideas, some argue that influential figures like Peel and Fry instigated necessary reforms that improved public safety and humanized the justice system. These leaders often serve as exemplars of change, proving that individual vision and action can lead to substantial societal progress. However, these figures also faced challenges and controversies. Peel's policing model initially drew criticism for potential abuses of power, while Fry's reforms were seen by some as too lenient. Additionally, the impact of institutional biases and systemic inequalities continues to spark debate on the extent and nature of reforms introduced by such figures. The influence of these figures extends across various aspects of the topic, intertwining with legislation, law enforcement practices, and societal attitudes towards punishment. They exemplify how individuals can drive changes that resonate across time, prompting ongoing reflection and adaptation of policies within the UK justice system. Understanding their contributions provides valuable context for the current state and future directions of crime and punishment in the UK.